I'm joined now by Karel Bredenkamp, Director of Bredenkamp Patent Attorneys. A very good afternoon to you, Karel. Thanks very much for your time. Interesting what the outgoing Deputy Chief Justice had to say in his reasons that the SCA had failed to give reasons for overturning a previous High Court decision. I don't know what you made of that, or whether it's even something you as lawyers are even accustomed to.
Good afternoon, Vuyo. Yeah, thank you. It's never happened to me. You know, you normally appeal upwards and not downwards or sideways. And the statement that it was, unfortunately, I haven't seen the whole judgment. I would love to get a copy of the written judgment. But the statement that the Supreme Court of Appeals was unfair and irregular, then, you know, that's quite a statement. And it is quite frustrating that this matter cannot proceed to finality. At some point, a court must make a judgment and call it a day. It's been going now for how many years? It's one of the longest running cases almost that we've had in this country, I think.
And not only that, he also says that, I mean, the case had been going on for 20 years, to be exact. And then Judge Madlanga says it must also be heard by a different panel of judges.
Yes, that's correct. So, you know, that is quite a harsh order to make, I suppose. But yeah, I wish he made a final judgment in this point. But I don't know the exact facts why he referred it back. But I think it is unfortunate. I think you know, one of the courts must now make a final judgment in this matter.
What for you, though, is at stake here? Is it an issue of someone disputing that this patent belongs to Mr. Makate, who is on our screen? Or is it a question of a big corporate citizen just not prepared to part with the kinds of amounts that he thinks he is entitled to?
Well, if I remember correctly, they did make an offer of, I think, 47 million rand, and I think that was quite a decent offer. I don't know the opinion of the legal team, of course, but according to me, that would have been a good offer, because the alternative is to just be tied up in court forever, as we now see. And it's difficult to move on from there. You know, I do think there's always that you know, big corporate, the big corporate bully, but also, you know, you must look at the employee. I mean, the employee must also learn to protect their rights and to be a little bit more careful. There wasn't a patent. The idea wasn't patented. The idea was disclosed. And the manner of disclosure is, of course, very important. You know, if you disclose something to someone and say, I disclose it to you for the purpose that we can both make money out of it, that is a qualification on your disclosure. If you on the other hand have a patent, that would have made it much easier, and you could have entered into an agreement with your employer, possibly. And that would have made the whole process quite a bit quicker. I'm absolutely 100% certain that would have been much quicker. But in any event, even if it wasn't patentable, the idea, if the employee, if you have a new idea, go to a patent attorney and see if you can protect the idea before you disclose it. And even if it isn't patentable, there are other ways of protecting it. Like I just said, through qualifying your disclosure to the person or the party that you disclose your invention to.
Let's say we both move from the premise that both employer and employee have every right to protect themselves,
Yeah.
you know, and to fight for what they believe, for what they believe in. But let's just say, and I'm not saying this was necessarily the case in this instance, that you're working for this company, and you're doing your best, like every other employee, to actually make this company work, make it grow, and so on, and so forth. But you come up with something so unique, and which was not part of your job, all right? But your expertise, your knowledge, you know, goes beyond what you're employed to do at that particular point.
Yes.
Is there no case to be made to say, you know, you're entitled to fair compensation, whatever? We just get into the nitty-gritty or the detail of what fair compensation may constitute in a case like this one or a similar case. But is there no case to be made there to say, but there's a unique set of circumstances here, including being full of zest and enthusiasm to a point where I actually go beyond my call of duty?
Yes, the general rule is that if you invent something to your employer's advantage, and you're not employed to make that invention, you're employed to do administration, for example, and you invent something technical, then as a general rule, you can assume that invention will belong to you. And then it's up to you to commercialize it. And of course, you know, then other things come into play. You don't want to interfere with your normal working hours and things like that. But as a general rule, you can say, yes, definitely, if it's outside the scope of your employment, your invention belongs to you. And in many cases, and we have it many times, you know, many clients come to us and we advise them when they enter into a employer-employee relationship. We look at those agreements because those agreements normally deal with intellectual property and the ownership of the intellectual property. So you have to be very careful when you enter into a new employment agreement, and people are normally very excited to enter into a new employment agreement, and they don't look at the employment agreement properly. And then later on, it becomes a difficulty if you sign away too many of your rights in that employment agreement. But, you know, as a general rule, if it's outside the scope of your employment, that invention probably belongs to you. And you can then enter into a separate agreement with your employer or with anyone else for that matter. If you once, and that's the important point, I think, just get legal advice. You know, it's the advice on just finding out of an invention or an idea is protectable. That should be free, really, and you can then move from there. So that would be a very good first step to just get some advice, because that costs you almost nothing. So
in addition to those, in other words, making sure that you patent your idea if it's patentable, get good advice beforehand. What else has this case actually brought to the fore or thrown up?
You know, it's been going 20 years. That to me is actually it's actually not very satisfactory. You know, we need to get our courts. Our court cases heard quicker. You know, some cases we set down at the moment, and you get a court date many years in the future, which is not it's not a good. You know, the system has to be improved. I think that's really it. This case, of course, has different difficulty because there wasn't proper agreements from the beginning or written agreements from the beginning. So it is in itself already a difficult case, but I don't think it should necessarily have taken that long.
Karel Bredenkamp, let me thank you very much for your time. Director at Bredenkamp Patent Attorneys.